Hello everyone and welcome to the Refugee Study Centre at the University of Oxford. My name is Catherine Briddick and I'm a lecturer here. I work on international human rights and refugee law. We're here today to discuss the British government's attempts to partially externalise refugee protection. So on the 13th of April this year, the UK government signed a Memorandum of Understanding with the Republic of Rwanda on what is described as an asylum partnership arrangement. This agreement seeks to enable the transfer or deportation of asylum seekers from the UK to Rwanda to have their claims determined there in accordance with Rwandan asylum and immigration law. The policy potentially applies to people who are already in the UK and indeed to anyone who arrived this year. Now, this agreement seeks to create a two-tiered system in which some asylum seekers have their claims determined in the UK and have the limited rights that go with that here, while others have their claims determined in Rwanda. It's this discriminatory difference of treatment, as well as the political and legal context in Rwanda, that creates the potential for rights to be violated. Now, the policy has two legal foundations. The first is the immigration rules and a set of something called the inadmissibility criteria, which enables the Secretary of State to remove an asylum seeker to a safe third country under certain circumstances. And the second is the Nationality and Borders Act. This is a piece of legislation that, amongst other things, criminalises people simply for seeking protection in the UK, differentiates between and discriminates against different groups of refugees and denies them key rights, including to family reunion. Provisions in this act provide an additional or strengthened domestic legal foundation for the externalization of refugee determination and protection. Now, these proposals need to be considered against two legal contexts. The first is international law and the international protection regime, as the UK policy draws on those that have been used in other countries, including the US and Australia, to obscure and evade international protection obligations. The second context is domestic, and what I think can be characterised as democratic erosion or decay, as this legislation was passed alongside the Judicial Review and Courts Act, a piece of legislation that makes it harder for people to challenge decisions that affect their lives, and also needs to be understood in the context of the government's proposals to repeal and replace the Human Rights Act. Now, this panel discussion brings together four people whose experience and expertise makes them uniquely placed to analyse these developments and their consequences for both human rights and refugee protection. Our first speaker today is Lawrence Bottinick, representative ad interim of UNHCR in London. The second is Behrouz Boochani, an award-winning author, journalist, and associate professor at the University of New South Wales. The third is Baroness Shami Chakrabarti, CBE, a member of the UK House of Lords. And the fourth is Zoe Bantleman, legal director of the Immigration Law Practitioners Association. They're going to be speaking for about 10 to 15 minutes in turn, and you're going to have the opportunity to ask them questions using the Q&A function that you should see at the bottom of the screen. Thank you very much for joining us today. Thank you very much to our panelists, and over to you, Lawrence.
Thank you, Catherine, and good morning. UNHCR's observations on the border bill are very detailed in 100 pages. So let me just reassure you, I'm only going to try and make 3 points this morning. The first one is that the arrangement, we think, dangerously undermines the global cooperation on which the asylum system is built. Secondly, we fear it's going to lead to more dangerous journeys rather than less. And thirdly, we think it's unnecessary. There's cost-effective and much more humane alternatives that exist. So firstly, the concept, it's based on the false notion that you need to ask for asylum in the first country that you encounter. And the corollary of that is that the UK will only or almost only accept those it has invited. So people they've authorized to come. So that would be Ukrainians, but only those with a visa. Some Syrian nurses are okay, and Afghans, but only certain Afghans, those who come under a resettlement quota or were evacuated to the UK. The unfairness of this, if you look pre-Ukraine, some 85% of refugees were already in developing regions, and some 73% of were in states neighboring their country of origin. This exacerbates that. It signals to Lebanon, you need to keep all the Syrians. We know you have Iraqis, and we haven't forgotten about the Palestinians, but you keep them too. Pakistan and Iran, you keep your borders open for the Afghans. We are going to close ours, and we're going to invite all of our European neighbors to do the same. And those that do make it in, we'll send to a country like Rwanda, which is already hosting some 130 or 150,000 refugees on their own, despite being much less prosperous than the rest of Europe. So very few come to Europe as it is, and because the UK, being an island at the end of the terminus, gets much fewer than that. So this fallacy that everyone in France wants to come to the UK, if one looks at the numbers, that's truly not the case. There's no emergency here, but if Pakistan and Iran, Morocco, Kenya, Lebanon either get overwhelmed, and Lebanon already with its own population has trouble meeting basic needs, or they just feel the fool that everyone's closing their borders while asking them to keep them open. So if they refuse that, then we'll see the emergency. You know, one only has to see Lebanon collapse to see the numbers come out, similar to 2015. The notion that the UK is filled, I think even the green space came up. You know, the Ukraine scheme is uncapped, so that clearly can't be the case. The Hong Kong arrivals are huge numbers potentially. They're not risk-based, so it's not really a refugee flow, but it shows that the numbers that would come over the channel are manageable. The second point on more dangerous journeys, before I was posted to the UK, I spent 5 years in Israel. So I feel like I've seen this movie before because they were also sending Eritreans to Rwanda and Sudanese to Uganda. Most of the, almost all those sent to Rwanda were moved on to Uganda. Some stayed because there's a Eritrean diaspora there, but most moved on. And if one looks at the map, they moved from Uganda to South Sudan, to Libya, to the Mediterranean. So it's much more dangerous and hazardous journeys than we speak of with the channel. Now, even if Rwanda had A+ refugee status determination, there's a question about whether people will feel like that they can integrate and make a life for themselves, and whether they can truly integrate and make a life for themselves. Will a Farsi-speaking Iranian feel like there's a future there? Actually, we have one on the panel, so we could ask him what he thinks about that. But think of an Afghan woman maybe fleeing forced marriage in Afghanistan, finds herself in Rwanda. You know, officially French and English are languages there, but very few speak either. So my fear is that, like in the Israeli context, people will move on. Lastly, the third point, alternatives. The answer is to take decisions promptly. Right now, less decisions are taken in the UK than pre-COVID. If you take decisions, you move people out of hotels, which is where the expense comes, and into self-sufficiency if they have a refugee claim, which most of the boat arrivals do. Statistically, that's not me saying it, that's the Home Office determining their refugee status. There's good work on efficiencies being done on what they call legacy cases, people that are already here, but that's going to take time to work through that backlog. If you take decisions promptly, you can return people who don't have a legal basis to stay, and that also should be done promptly before people put down roots and then have other reasons to stay. So after a final rejection, you know, not everyone who arrives to the UK has to stay here. There should be consequence to a negative refugee status determination, just as there should be to a positive one. And lastly, and I know this is politically tough between fisheries and the Northern Ireland Protocol, but instead of putting energy and money and time into reaching agreement with Rwanda, they should do that with their European neighbors for an equitable two-way readmission agreement. So whether with France or to have it more binding with the EU, that's where the energy should be there. And if money should be put to stabilizing a population, it could go to housing for refugees in Spain and France, as that's one of the reasons people move on is the conditions there. But that would be more effective in our view than a deal with Rwanda. It would also be a more humane alternative, and it would promote the cooperation that both the convention calls for in its preamble and in the spirit of the convention, rather than undermining it. So let me end there, and happy to take any questions whenever there's the appropriate time for that.
Thank you very much indeed. Behrouz, over to you.
Yeah, thank you very much. Thank you, Catherine, for organizing this event. I think, so I have 10 minutes to talk. That's what you say. Yeah. I think, first of all, I want to introduce the article that I think I wrote it 2 years ago for New York Times. The title of the article is White Australia Policy Lives on Immigration Detention. So the reason I mentioned this article is that the audience, I refer them to if they want to read it. And in this article, actually, I try to look at the policy towards refugees in Australia on basis of colonialism mentality and history of colonialism in Australia, because what is happening now and what has happened towards refugees and the whole policy is on based of that, and we really cannot understand it without history of colonialism in Australia and what they have done on Aboriginal and Indigenous people in Australia. And in this article, I try to explain that. When I arrived in Australia on the 23 July 2019, actually, we didn't know that they announced a policy called 19 July policy. And according to that policy, anyone who comes to Australia by boat and seek asylum, they banish them to Manus Island in north of Papua New Guinea and Nauru Island in Pacific Ocean, both islands in Pacific Ocean, and keep them in indefinite detention. And so that is the whole policy. We didn't know about it. Most of the refugees who spend more than 6 years, some of them more than 8 years, and some of them 9 years in indefinite detention. I myself, I was in indefinite detention for more than 6 years. So most of us didn't know about it at all. We were on the ocean. In that day, they announced the policy. And so that's why I call it as a hostage taking, you know, and just they arrested us on the ocean and then sent us to Manus Island. So I was there, and when I arrived there, I saw that a group of refugees were there. They were families. And I had this chance to ask them a question that, what are you here? How long you have been here? And they say that actually we are refugees and they sent us here on 2012. And after a few days, they transferred them to Australia and replaced them with us. So they transferred them to Australia. And later I could see in the prison camp that there was some sign in the prison camp, and I could hear that some of the guards, some of the local guards who were working there, they told us about refugees who were here, who were there long time ago. And later I found out that these refugees were part of a group of refugees that they sent them on 2001 and kept them in Manus prison camp for 6 years, and they released them on 2007. So actually that take us back to 2 decades ago, you know. And later I found out about Tampa ship, and that is a big story in Australia. So for anyone who want to read about history of immigration in Australia, and they should know about this, that on 2001, John Howard, the Prime Minister of Australia, he stand up in the Parliament and he said that we decide to come to this country. And he said that because of a big ship on the ocean with many refugees, and they stopped, Australia stopped them, and they prevent them to enter to Australia. And so they kept the refugees on the ship for, I think, a month. And finally, some of them were accepted by New Zealand, and some of them, they sent them to Manus Island. And so they established this detention industry that we are talking about. So I mean, the reason I mentioned this is that for understanding of this policy in UK, we should really understand what happened in Australia. And for understanding what happened in Australia, we should go back and read the history of this. And even that Tampa ship story on 2001, actually, even if we follow that, we see that that happened in history of Australia a lot. But that happened, this kind of crimes and tortures and keeping people in indefinite prison camp, that happened on indigenous people in Australia. So I mean that we are facing a model, we are facing a mentality, you know, and that's why we should really understand where that started, you know. And even these prison camps, the way they design this prison camp actually is on based of other camps in Europe in Second World War, and before that in even the 19th century. So I mean, this history actually, we are facing the same mentality, you know, and same system, which always has been developed, you know, year by year, and now became like a complicated and a modern system, you know, that we have it in Australia, and now that is happening in UK. And to be honest, for me, long time ago, 6 years ago, 5 years ago, when I was working in Manus prison camp, I expected that, you know, I wrote this, I wrote about it, that what is happening here is not a matter only for refugees, is a matter for everyone, and also is a matter for everyone around the world. So it is a global matter, because Australia has done this, has established this industry, and that will affect on other countries, and other countries one day follow Australia. And now that happened. you know, a same model, and that was introduced by a same person, by Tony Abbott, the former Australian Prime Minister, that he introduced that to UK and British politicians, you know. So I mean, they you know, they introduced it. They produced violence. They produced violence, and that violence now is spreading around the world. And now we have the UK. So I mean, we can talk about this later. That is really important for me as someone who expected that one day other countries follow Australia. It's not shocking for me, actually. I expected that, not only me, many people in this part of the world, we expected that. But I really like to have this chance. So later, so I want to finish my words, but to talk about this, that how this policy effect on refugees. Of course, refugees are the first victim under this policy. They damage the refugees mentally and physically, and also how this policy damaged Australia as a country, as a democratic country, how this policy damaged the political culture in Australia, you know, and how this policy led the populist politicians to get power, increase their power. And just last sentence, Peter Dutton, the former Australian immigration minister and then home affairs minister, now he is the leader of Liberal Party in Australia. And that man, over the past decade, year by year, he has increased his power. And when he was the minister, he was the most powerful minister in history of Australia. And he did that on the refugees because of this policy. So, I mean, what UK is going to do, of course, that damage the refugees, but one day damage the whole country and undermine the principles and the whole political culture. Thank you very much. We can talk about this later if you are interested, so I can give you some example. Thank you.
Thank you so much. Thank you, Lawrence, for providing us with the international context and explaining some of the potential impacts of this policy for the international protection regime. And thank you so much, Behrouz, for giving us some historical context and analysis. And I think your closing comments about the effect that these policies have on domestic politics and domestic rights protection takes us perfectly to our next speaker, Baroness Shami Chakrabarti. Over to you.
Thank you so much, Catherine, and thanks to the Centre for including me in such an important discussion. You can't see because I've drawn the curtain for lighting purposes, but I'm actually speaking to you from Brighton. So behind that curtain is a wonderful sea view, but I've covered it up for reasons of lighting and seriousness of the occasion. And I'm in Brighton because I've been speaking to a trade union conference here, to the PCS union, which is the main public sector union. And interestingly, it includes border force officers and Home Office caseworkers. And I'm very proud to say that it's this union that is behind the litigation that challenged successfully, actually, stopped the odious channel pushback policy, and more of that in a moment. But also the same trade union that represents, amongst other people, border force officers is standing behind, financially standing behind the litigation on the Rwanda Pact, as I call it. It's important to point out, as Larry did in his important introduction, that the dirty deal with Rwanda is not a treaty. It's very explicitly not a treaty. It was not negotiated by our foreign secretary. It was cooked up by our rather notorious Home Secretary, Ms. Priti Patel. It's an MOU. It's not a treaty registered at the UN, etc., etc. And it's an attempt, of course, to contract out of the Refugee Convention. And I'm very proud to say that it is trade unionists, including border force people, who are funding this litigation. And I think that is part of the political antidote to everything that Larry and even Behrouz were trying to set out. Because yes, policies like this are demeaning to everyone, to the refugees, but also to the societies that should be treating their fellow human beings a little better. And it's not an original analysis. It's the old Holocaust poem about first they came for, and we are seeing this with the wider political and legislative agenda in this country. You attack the Black Lives Matter and the climate activists with your public order legislation. You attack the independence of the Electoral Commission with your Elections Act. You attack refugees via your Nationality and Borders Act. And where is it all heading? The so-called new Bill of Rights, which is a truly Orwellian abuse of language, because it isn't a Bill of Rights at all. It is a license for more executive domination of Parliament, of the courts, and of everybody's rights in the country. So it literally is like the poem, first they came for the refugee and then they came for me. Not an original analysis, but I in short, I agree with Behrouz on that. But I want to hark back to the fact that I am speaking from this trade union conference, because I want to give hope and not just misery, which is my usual diet at the moment. So I want to share a little bit of hope that from this conference and from the litigation and the activism that is beginning to respond to this terrible far right populism that we are currently seeing from Mr. Johnson's government here in the UK. Now, amongst other things, I mean, my background is that I'm a human rights lawyer, an activist, and now a legislator. And earlier this year, the Home Secretary, Priti Patel, gave evidence to a committee on which I sit in the House of Lords, and that is the Justice and Home Affairs Committee. And it has, some very august people on there, former Home Secretary David Blunkett, now Lord Blunkett, and it's a cross-party committee. So Liberals, Labour people, Conservatives, and crossbenchers on that committee, including retired Court of Appeal Judge Lady Hallett, and so on. It's a pretty serious committee. Priti Patel came to the committee to give evidence, public evidence, and of course we quizzed her about the Channel pushbacks policy. And she was very adamant that this was appropriate and totally required, because everyone in these little boats was a bogus refugee. They were all young men, and they were all elbowing women and children out of the way, further upstream in Afghanistan or wherever it is they're from. They're elbowing the women and the children out of the way. They're coming in these little boats. They're feeding the evil trade in trafficking, which I think is quite ironic, given the Rwanda transportation policy. I ask you, who is the trafficker now? Is the Rwandan policy not a form of state-sponsored people trafficking, even with money changing hands between the two governments? But I'll park that for a moment. Priti Patel swore blind to the committee that this policy was necessary to deter these asylum seekers who were all bogus. The crucial thing is that this was about asylum seekers, not just any kind of migrant. It was specifically aimed at asylum seekers, and she told us there was a legal basis for it. She had consulted lawyers and there was a legal basis. That was the phrase that she kept using. Fast forward, The litigation, the judicial review, is brought by the PCS Union and Care for Calais, a campaign group, but made possible by the PCS standing behind on the costs risks, which is a really important point. And what, obviously, to have this judicial review, you need to see the Home Office policy document. But the Home Secretary asserted something called public interest immunity over this document. So they wanted the document, the policy, to be secret. Now, there's no secret that they were going to turn around little boats in the English Channel, which, by the way, Behrouz was talking about, Australia's, terrible, the darker part of Australia's history, which is what was perpetrated upon Indigenous people. But, every country has light and shade in its history and in its myth. And I would say that the political antidote to all the misery that we've just heard about is to remind Australians that many of them were descended from poor people who were transported to that territory. So yes, let's tell the story about the darker sides, but let's also build solidarity between people, because far-right politics is about division. It's about divide and conquer, and everyone's getting conquered. So white Australians as well as refugees, it's division, it's turn people in on each other. And so what we need to do is to capture the more uniting parts of our history and our national myth. And I would say that the British national myth, Britain's finest hour, Winston Churchill and all that, is supposed to be the Dunkirk spirit. So I call the pushback policy the anti-Dunkirk spirit, because we're supposed to be saving people in little boats, not turning those boats around or even capsizing them. Anyway, she gave that evidence to the committee that she asserted secrecy over her policy. The courts wouldn't wear it. And when that policy document had to be made public, we could see that that it was never intended to turn around boats if someone said, I want to claim asylum. So the Home Office lawyers had realised and had advised that if somebody in the English Channel says, I want to claim asylum, you have to escort that little boat to the English shores and proceed with their claims. In other words, the Home Secretary lied to Parliament and lied to the electorate about that policy. And then when they were dragged into court, they tried to keep the policy secret and just give the judges a wink that it was all going to be okay, because they weren't actually going to turn around boats if somebody said, asylum, please, which shows the importance of judicial review and the rule of law in all of this. So now they're not worried about pushbacks anymore, because they're going to use the Rwanda Pact as their deterrent. And you know what I think about that. I think it's an attempt to contract out of the Refugee Convention. It is a form of transportation, trafficking, whatever you want to call it. And it has rightly caused enormous outrage here, including comments from the Archbishop of Canterbury using his Easter Sunday address. And you'll appreciate, that the Church of England is the established religion in this country. It is interwoven with the state still, and Easter Sunday is the holiest day in the calendar. And for him to call this policy ungodly is really quite significant, even for lots of decent conservatives with whom I don't agree on socio-economic policy, but with whom I agree about fundamental rights and freedoms, including the right to asylum and the rule of law. So that's a little bit of hope about what we must do in our narrative as we fight this far-right, xenophobic, divide and conquer populism going forward. I so agree with Larry's analysis of the Nationality and Borders Act. It's a total travesty, and again, in so many ways, it undermines the convention. And I so agree with Larry also on his analysis of this attempt to have good refugees and bad refugees, but ultimately nobody's going to be treated properly. We will offer special executive largesse for the refugees that we consider to be the ones we like, people from Hong Kong, from Ukraine, And instead of taking the Ukrainian situation as a moment to say, look at what public sympathy can be, and let's expand that public sympathy to all refugees and not just the ones that we choose for this moment to be nice to. The government is trying to differentiate, divide and conquer. That's their political approach. And of course now the British Bill of Rights is promised, which will, we're told, break the link between the domestic courts and the Strasbourg courts. Our courts shouldn't even take account of that jurisprudence anymore. We're told that our courts won't be able to interpret legislation compatibly anymore, which is one of the most important features of our Human Rights Act, which is our progressive modern Bill of Rights. And we're told that in this new so-called Bill of Rights, that rights will be contingent on British nationality, on displaying significant hardship, and on good behaviour. So all those contingencies and very little by way of teeth or enforcement. So it's a travesty. It's not a Bill of Rights at all. And that is a big fight that we have ahead of us, because they've already driven a coach and horses through the Refugee Convention, and now they want to do it in terms of the European Convention on Human Rights as well. But I do think that there is a mood amongst the public, not least because of all this nonsense about partying during lockdown. There is the potential there for people to see that this is a government that does not believe in the rule of law. So it's one law for these elite millionaires and billionaires in the cabinet, and another law for everyone else. Yes, it's been easy to demonize refugees, but now we can see that other people are being marginalized and demonized too. Cost of living crisis, all sorts of issues. And the answer to far right populism and divide and conquer is frankly a popular front, policies and narratives, historical and current, that unite people when they seek to divide us. Thanks for listening.
Thank you so much, Shami, for sketching out some positive narratives, some opportunities for challenge and for growth, and for resisting some of these measures. Having thought about political options, we're now moving to Zoe Bantleman, who's going to talk us through some of the legal and other challenges that are currently underway. Over to you, Zoe.
Thank you, Catherine. Thank you for inviting me to hear from such esteemed colleagues on the panel today, and to hopefully try to contribute something to this discussion. The Act and all of its resulting challenges is simply too large of an area to cover in the limited time that we have. So I'm just going to try to focus on one problem at the core of the Act's asylum provisions, and how we can see the Rwandan agreement as a microcosm of the same problem before I move on to consider some avenues for legal challenge at a policy and individual case level. So the core of the problem that I see is penalization of persons seeking asylum on the basis of their irregular entry. This is at the core of the Act in Section 12, previously Clause 11, and in its differential treatment of refugees, so categorizing them into Group 1 and Group 2. To differentiate refugees, the government relies on its reinterpretation of the Refugee Convention. So Section 37 of the Act, it applies retrospectively, and it unilaterally reinterprets Article 31 of the Refugee Convention, and thus who is immune from penalties under that convention, in a way that departs from the jurisprudence of our courts. So sitting in the High Court, Lord Brown, in the case of Adini, actually held that any mere short-term stopover en route to a place of intended sanctuary cannot forfeit the protection of Article 31. And that was also upheld by Lord Bingham, of all people, in the House of Lords, as it then was in ASFA. But the government has reinterpreted that article, and the purpose of that is to catch persons who've stopped over in other countries or who have delayed in making their asylum claim. And they argue that their reinterpretation and the implementation of it is done in good faith. All of this, I think, embraces a wider question about the rule of law, as Baroness Chakrabarti said, and also the role of our courts. Through reinterpretation, the government has taken into its own hands the interpretative function of the courts without any explanation as to why or how our courts have misinterpreted the convention. And Baroness Chakrabarti actually did an incredible job in the House of Lords trying to open avenues up until the last minute of the bill's passage to consider the compatibility of the Act with the Refugee Convention. But the government, of course, wanted to close off any chance of the court's consideration, just like it's trying to do with the Bill of Rights. So this is really part of this wider scale agenda of the government. However, for this particular discussion, I think what's crucial to note is that the offshoring and inadmissibility regime appear on their face to be procedural penalties, which follow also from an irregular mode of arrival. So they're based on a person's connection to a safe country, but they're a microcosm of these same issues and are also going to be exacerbated by the Act as certain provisions within it come into effect. So they're a microcosm of the government's interpretation of international law and permitting it to shift its responsibilities to a different place, to a different government, but also they delimit the role of the domestic courts. So Schedule 3 of the Act will prevent in and out of country appeals against an asylum claim or a human rights claim that has been certified as clearly unfounded, to leave the only remedy as judicial review. And on that list of atrocious bills which have recently passed that Baroness Chakrabarti mentioned, one of them she didn't mention was the Judicial Review in Courts Act. And we know now as well that the government is coming for judicial review, and that might not be the only act. There might be further acts in future parliamentary sessions that we're anticipating. Therefore, I think the question which the courts and practitioners and academics need to address in the months and the years ahead is whether this particular type of domestic procedural penalty is in breach of Article 31 and where that leaves us in the courts when the avenue for such breaches is actually paved by primary legislation in the Nationality and Borders Act. I think it's also important to do what Larry and Baroness Chakrabarti have done in trying to deconstruct the myths that underpin the agreements of this idea that it's based on protection and deterrence and that there are safe routes. Because we've seen that the way that the Rwandan policy is built is that it applies to anyone who has arrived in the UK after the 1st of January. But as you said, Catherine, it was only signed on the 13th of April. So it has this punitive effect and it applies retrospectively to people who may have not been deterred because it wasn't in place and who may have already been smuggled and who are here. And so whilst the new inadmissibility guidance, it puts in this priority for relocation for people who have arrived in the UK after the 9th of May, that really means little when it can retrospectively apply, and that was the purpose of the policy. I think also we do need to critically examine these bespoke safe routes, as Larry and Baroness Chakrabarti have done, to really think about how they uphold the narrative of the government, that it's world leading, that it's generous, when these safe routes are too few and too narrow to replace the convention that's being reinterpreted by the government. So just to move on briefly to some policy challenges, I'm sure all of us know what the challenges are just from opening The Guardian these days. They seem to be laid out quite well. So the first one, which is the one that Baroness Chakrabarti mentioned, was brought by Detention Action, Care for Calais, and the PCS Union. And that was on the basis of failure to disclose the criteria for selecting who's transferred to Rwanda, and thus who remains in the UK, breaching the duty of transparency and the right to access to justice. That policy and that selection criteria still remain unpublished by the government. And I think it has a very clear intention now not to publish these because it doesn't want to be critiqued on the basis of the selection criteria, but we'll see how long these stand and whether there is a secret policy that's running in the background. The second ground that they brought it on was on the basis of penalization in contravention to the Refugee Convention. So as I say, I do think this is a crucial limb that runs through the Act and also through the policy. And I'm sure anyone who opened the papers this morning or last night will have seen that Freedom from Torture has now sent a letter before claim to challenge the policy on 4 grounds. The first is that it's irrational to conclude that Rwanda is a safe place on the basis of the evidence. The second was that, given that Priti Patel made quite clear in her speech on the 14th of April that she thought that Rwanda was a safe country, but only published her assessment in May, she may have been biased or predetermined in her assessment of the evidence. The third is that it's in breach of her common law duty not to induce breaches of the European Convention on Human Rights, including Article 3, and that it's contrary to her duty under the Asylum and Immigration Appeals Act to comply with the Refugee Convention to then enforce removals where there's evidence that suggests that Rwanda will not observe its obligations under that convention. But interestingly, there's another prong of sort of legal challenges that are underway, which are looking at the lawfulness of transferring people's personal data to the Rwandan government and the policy's compliance with data protection laws and GDPR. And I think the latter group of challenges are interesting and crucial because we need to consider how we can use the wider lens of domestic law outside of asylum, human rights, and public law to examine the legality of the proposals. If we know the government is coming after human rights law, it's come after judicial review, it's come after asylum law in the past year, then how is it that we can use the rest of the domestic legal system like tort law, like data protection law, in order to really look at the proposals and try to challenge them in the legal context? And then to turn to my last sort of prong, which is about individual challenges. So I think there's still quite a good scope for bringing individual challenges even under the policy. And I don't know whether she intended to or not, but the Home Secretary's own assessment of the asylum process and system in Rwanda is a little bit more damning than I thought it might be in terms of what was published. So there are quite a few concerning aspects of that. It's still difficult to determine, as I say, whether the selection criteria is discriminatory, whether under Article 3 of the Refugee Convention or Article 14 of the European Convention on Human Rights, because we don't know on what basis they are sending people. All we know is that the Equality Impact Assessment says unaccompanied asylum-seeking children will not be sent, but it happily accepts that there is going to be a greater impact on certain nationalities like Iran, Iraq, Sudan, Syria, Afghanistan, and also persons of Muslim faith and young adults, so age 18 to 39, it happily accepts will be more greatly impacted by the policy. Interestingly, instead of people when people are arriving in the UK on these small boats, taking these dangerous journeys, they are being detained on the basis that they can be removed to Rwanda in a reasonable timeframe, and then they're given 7 days to make representations against this notice of intention. So it's a little bit of a chicken and egg situation as they're using Rwanda as the basis to detain people on the basis that they can remove them to Rwanda in a reasonable timeframe. And we know that at least 50 people have been served with these notices of intent. It's an extremely tight time frame for a person to be served with a decision, to find a legal representative, to get legal advice, and to make representations about why they shouldn't be removed to Rwanda within 7 days. So ILPA, the organization that I work for, but also Detention Action and Bail for Immigration Detainees, recently wrote to the Legal Aid Agency about these schemes and are worried about the inadequate availability of legal advice. But that really runs throughout the entirety of this transferring process, because when you look at the country policy notes on Rwanda, the same worries are on that side. So it's not clear, for example, whether a person will have access to legal advice when they're making their initial asylum claim. It appears from the Home Office's country policy note that actually a person will only have access to legal assistance at the point when they want to appeal to the High Court of Rwanda, which is actually their sort of secondary appeal review system. The first review system isn't really an independent review. You make the review request to a minister in Rwanda, and that minister was also sitting on the committee that decided to refuse your asylum claim initially. So there are some real concerns about the adequacy of legal advice throughout the whole process, from the moment that a person arrives in the UK and is detained all the way until they need to challenge a decision in the UK or in Rwanda. And I think there are plenty of bases to make different challenges to the various decisions, particularly on the UK side. So before a person is removed, the UK must comply with its obligations under the European Convention of Human Rights. People come within its jurisdiction under Article 1 of that convention. So we will be looking at a real risk of breach under Articles 2, 3, and 4 of that convention. We'll be looking at any sort of family issues in Article 8 of that convention. But I think what's really concerning is that the UK proposes to take some of the most vulnerable people from Rwanda in its Memorandum of Understanding, which sort of suggests that the vulnerable persons might be better safeguarded in the UK than they are in Rwanda. And it's very concerning then that the UK isn't carving out specific selection criteria for vulnerable people like trans women. So the guidance is actually very damning on Rwanda in relation to trans women and the discrimination that they face there. But there is no exception. The government isn't coming out and saying, we're simply not going to send trans women to Rwanda. So I think that's really concerning, this idea that everything's done on a case-by-case basis, and you're putting people which you know wouldn't be safe to send through the rigmarole of this process. I don't want to go on through all the different challenges that might be possible in an individual case, but to end, I just wanted to reflect very briefly on what our role should be in all of this. Us lefty activists, lawyers who are said by this government to be politically motivated to take the abysmal legal aid rates from the public purse to frustrate their plans, and how to think about that narrative and rhetoric. And I think I'm firmly of the view that all lawyers are very aware of their professional and ethical obligations. They know their duty to the court. They know their duty to defend the best interests of their clients fearlessly, to not bring vexatious claims. But I think this rhetoric is really dangerous, and in the past it's proven quite dangerous in a physical sense in putting lawyers' lives at risk. But I don't think that we should allow it to deter us from our duties. I think where there is ambiguity in the law, or where there are difficult circumstances like this, we can see it as an opportunity for all of us to come together, for academics in their pursuit of knowledge and truth, for activists and lawyers to consider the procedurally penalizing effects of this regime, and to try to develop innovative evidence-based legal arguments and analysis, and to draw from the other experiences like Behrouz's in Australia, to think about how we can hold the government to account to tackle this new asylum system. And as Baroness Chakrabarti said, to uphold the rule of law. Fundamentally, that's our job, and to protect the role of the courts and the constitutional and fundamental right to access to justice, because I think that's what we're all here for.
Thank you so much, Zoe, for showing us how illuminating really good legal analysis can be, and for alluding to both the domestic legal framework, but also the ethical framework that lawyers and others work in. Now, very much, I'm going to leave it there, although I could ask my fantastic panelists questions all morning. They're all very busy and have to get back to their main jobs. So thank you to Lawrence Bottinick, Behrouz Boochani, Baroness Shami Chakrabarti, and Zoe Bantleman. And as I said, I'll tweet the various things that we've talked about throughout the day, so you can read more about UNHCR's position, and you can access ILPA resources by following those links. Thank you so much, everybody, for joining us from so many different countries and so many different places around the world. I hope you have found this conversation useful. If you're interested in RSC online events, do have a look at our website. You can find out more about the other seminars we have this term and our international online school in forced migration. Thank you once again to our panelists, and thank you to everybody for joining us today.